This is the last, the fifth of a five-part series of the Practical Law Office Management Ethics and Malpractice, Chapter 3 of Cynthia Train-Adonis' book. And we're going to cover resolving ethical practices and malpractice. And this will be a really quick one because it's brief. We're going to talk now about resolving ethical problems in Chapter 3. First of all, ethical problems are, pretty much inevitable. And it's important to realize that it's not a good idea to try to resolve them by yourself. If you feel like there's an ethical issue that you need to, that you're curious about, or that's come up in your world that concerns you, a client comes in the door that you realize is somebody that you've worked with before in the past, maybe at another law firm, maybe it's someone from your community center or church or something that you have a conflict with. I don't know, just some ideas. Maybe it's somebody that you sued. Maybe you had an agreement with somebody that just, all of a sudden they're your client, the firm's client. These can be ethical problems. So the best thing to do is get help with ethical problems, because there isn't a black and white to ethics. There are some, but even if you look at the conflict of interest one we just talked about, it's black and white. We know we're not supposed to give up client information. However, under the circumstances of finding a new job, you might be asked for a list of client names and how to resolve those. And I think as a legal assistant or paralegal or office manager, whatever the role you have is, you're subordinate to an attorney, a supervising attorney or a partner in the firm, someone who manages conflicts as part of being with the firm, part of their job with the firm. It's important to involve other people. Don't not say anything. And I think that was also discussed in the last lecture. So again, without that black and white, talking to someone else about the, whether it really is a conflict. Sometimes something that looks like a conflict on its surface really isn't when you look at it a little bit more closely with someone else who's trained to look at them. Keep your skills updated in terms of competency. Professional paralegal associations, I mentioned that in the third of the 5-part series. And know that it's important that you have competence to do your job, and that you maintain regular updates to your profession. Know your ethical rules, the rules of your state and the rules of your state and the rules of your organizations like NALA and NIFPA. Those are good helpers to make sure that you're staying on top of things and being reminded of your ethical issues. Legal assistant periodicals have excellent resources for both ethical issues as well as for continuing education to maintain your competency. If you know of an ethical violation going on, this book says report ethical violations to the state bar. Okay. But I would go back to the first one listed here first before just making that decision that I should go to the state bar with something. It's important to, again, without a black and white situation, what ethical violations would I make to the state bar? If I knew a lawyer was misusing client funds and trust accounts, I would head myself over to State Bar Association so fast I can't even think. However, if it's something about a potential conflict of interest, I would want more information, or at least want to report it to someone within the firm. In fact, I think even misuse of trust funds is something to report to the firm. Eventually, the state bar should know about something like that for sure. And I mentioned this in the last, in the UPL, the unauthorized practice of law thing. Think conservatively. I mean, especially where it comes to the practice of law. When I mentioned my story of when I first started as a paralegal in this law firm doing foreclosures in Denver, and I was so conservative. I was overly conservative. But you know what? Where it comes to unauthorized practice of law, some experience to recognize it is needed. So if you've not experienced it at all, you're going to go in there conservatively because, of course, we've at the school have reminded you over and over again that it's a felony, that it's unfair to the client, that it can cause major problems in your life and the life of someone else. So that's something, I think that's the one to be the most conservative about as far as everything we've learned here. Don't ignore problems that you see. Go back to number 1 here on this list. Don't ignore or procrastinate the problems that you sense are there. Get help right away. Talk to someone in the firm to ensure that you're okay. Malpractice. Legal malpractice occurs when an attorney's or a law office's conduct in representing a client falls below the standard skill, prudence, and diligence that an ordinary lawyer would possess or that is commonly available in the legal community. So what's looked at, if you think about an expert witness, let's say there's a trial going on about malpractice and an attorney being sued for malpractice. Well, sure enough, the attorney and the plaintiff's attorney are both sides are going to want an expert witness to explain to tell the jury that the conduct used by the attorney being accused of malpractice was either fell at the standard skill, prudence, and diligence that an ordinary lawyer would possess, or that is commonly available in the legal community or not. So it depends on which side you're on. So look at it that way. It's hard for a paralegal to really immerse in this piece of malpractice, but it's covered in here because I think more than anything it relates to your conduct and how you maintain your credentials, that you continue to learn, and I think that's where a paralegal really falls into malpractice. But malpractice is important to understand because if you don't have the appropriate skills, then your attorney is the person who may be faced with the problems. So what about the common questions that happen all the time? Can I have a business card? Paralegals in many states have business cards. Some states allow for paralegal's name to be on law office letterhead. But no matter what, that business card, that letterhead, even if it's not the letterhead and it's a signature on a letter, always make sure that what you sign, what you hand to people, especially when you get the opportunity to do so in writing, says, I am not a lawyer. You do that by using your appropriate title. You don't have to say I'm not a lawyer. You're going to say I'm a paralegal. And you're going to remind people that you're a paralegal, not a lawyer. Also, you may sign letters on office letterhead. It's perfectly okay to do that, as long as you sign your name as a paralegal, as I just noted. So you'd say paralegal, Suzanne Bechtel in my case. When you sign letters, always think back to that UPL topic. Does this letter contain anything even remotely resembling legal advice? And if it does, you need to change that signature block to the lawyer's name. I will tell you the truth, aside from very few circumstances, I didn't sign letters when I was a paralegal. And the reason why I didn't, I had 2 reasons. One was, this is the attorney's business, not my business. And I think that it's important that the client know the attorney is serving the client, that I'm there as a helper to the attorney. It was a way of avoiding, the mistaken, unauthorized practice of law, in case there was something that someone wanted to interpret as legal advice in there. It also has another benefit of your attorney knows that you're working on things, that status is happening. So it's up to you, or your attorney, whether or not you can sign something on letterhead. It's perfectly okay. Just keep in mind some principles that I followed, and I avoided it. I might have a letter to the clerk of court, which we don't even do anymore. But back in the day when I was a paralegal, we could actually write a letter to the clerk of the court and it wouldn't get thrown away. I'm talking about like a cover letter, exchanging a complaint or something. But everything is so different now that that's a bad example. And also, they profess in the book, and I talked about this before under UPL, can I tell a client anything about the fees? The author of the book is of the opinion that you should not, even on a preliminary basis, even discuss a fee range. However, I add that talk to your attorney about this, because in unauthorized practice of law, something that I didn't cover, and I didn't use the terminology, but if you're a conduit of legal advice or even legal information like setting fees, or you're asking the attorney, tell me what to tell these people. So it's not your legal advice. It's not your judgment. It's not your legal analysis that's been used to communicate it. It's the legal analysis of the attorney you work for. That's how I would spin that. I think it is perfectly okay. And correct me if anyone wants to argue with me, that's fine. But I think that it's perfectly okay for a paralegal to ask a lawyer, is it okay to quote any kind of range of fees for the type of service that you do? If so, what should that range be? And then, as I pointed out in the previous UPL lecture, was that it would be important to add to that conversation with the client, the potential client, that big however, you need to talk to the attorney. It could be your situation is going to be what regulates what's going to happen. So malpractice, back to that. I guess these slides are a little out of order. I didn't notice that. Most of the common causes of legal malpractice are failure to know or properly apply the law. Some examples from the last was, talking in the competence area. That was, don't take on work that you don't know how to do. The lawyer should not take work that they don't know how to do. They shouldn't take work that they don't have the staff for. They shouldn't take work if they're so overwhelmed and they have too much to do already. That's going to let things slip through the cracks. Making sure you maintain deadlines by checking the rules and making sure that you're watching deadlines and calendaring them in a calendaring system like we've already talked about already. Another one is inadequate discovery and investigation. That relates right back to the previous lecture where it's like you, as a lawyer, your diligence means you need to look for all the appropriate facts that go along with this case. If you don't get consent from a client to share information or informing the client of what's going on, and a planning error, choosing the wrong direction of the case. What are we planning it based on the many factors, like when an attorney chooses the wrong direction to take a case. That might be a direction, as in, this is how we should approach this case under this area of law and not that area of law, or couch in. This kind of thing can happen. So be sure that to recognize that legal malpractice occurs when an attorney's or a law office's conduct in representing a client falls below the standard skill, prudence, and diligence that an ordinary lawyer would possess, or that is commonly available in the legal community. And this list will tell you what are the most common causes of legal malpractices. Things that a paralegal can do to ensure, as far as she is concerned about her role in avoiding the attorney's malpractice: return client phone calls. Do this immediately. Have a policy for yourself. I will return all calls and emails within 24 hours. An example: send status reports to clients. Contact them regularly. Reduce fee agreements to writing. Resolve any fee disputes. If there are disputes, lawyers want to resolve those. They really, really do. Work only on cases a lawyer is qualified to handle. If there's something you feel you've been delegated that you can't handle, be candid with the lawyer that you work for. A lawyer also will send an engagement letter that says, yes, we're taking this case, or no, we're not. Both will make, rejection of a case or the closing of a case is noted in the very end. or disengagement with the client. It's really important that as much get in writing as possible, including fee agreements. How to resolve common problems, and in conclusion, we've talked about resolving common problems, how to spot ethical issues and solve them, that confidentiality is so important to the attorney-client relationship, that again, ethics is rarely black and white, and ethics is very important to your attorney. So avoid mistakes. Remember your competence and your diligence and your duty to manage your work well is very, very important to the client and to you as far as you are getting by. Malpractice it's so easy to make mistakes. We talked about a couple: incompetence of just a simple number being written down incorrectly, but sometimes the mistakes will injure clients, and it's important to stress the need for high quality work. Management has a duty to ensure that people in the law office understand that ethics is very important and will not be compromised. If management does not reinforce a strong ethical culture about the firm, around the firm, ethical behavior may begin to be commonplace. So the duty of management is to regularly train, regularly remind. I work in higher education, and I'm regularly reminded to take another webinar on sexual harassment or Title IX, which involves discrimination in the higher education venue. Management can do things to ensure that there's a reminder constantly out there. And plus, when they recognize unethical behavior, correcting it right away. So this concludes our lecture series for Chapter 3. It's been a pleasure, and thank you very much.